Hi, this is Josh Blackman, and welcome to the 2025 Harlan Institute Virtual Supreme Court competition. This is match number 3 in the round of 10. We have two excellent teams today. So representing petitioners, we have team 20135, Eileen Wang and Lisa Wang from the Baldwin School in Pennsylvania. And then from Creekview High School in Texas, we have team 20094, Lauren Holt and Caroline Reedy. Okay, counselor, petitioner, begin whenever you're ready.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court, my name is Eileen Wang, and this is my co-counsel, Lisa Wang, and together we represent the petitioners in this case. Texas House Bill 1181 restricts lawful speech by imposing chilling age verification requirements and compelling speech through mandated warnings. The First Amendment prohibits both.
The respondents rely on Ginsburg v. New York, but that precedent doesn't apply. Ginsburg upheld a narrow restriction on the sale of obscene materials to minors, which were in physical stores and where adults faced no meaningful burden. The online medium, however, is fundamentally different in that digital age verification inherently chills speech because it raises serious privacy and security concerns. And unlike purchasing material in person, the information there is transient and not stored and also bound to the physical location. HB 1181, on the other hand, forces individuals to disclose personal information simply to access lawful speech.
Also, this case turns on a deeply flawed threshold, which is the 1/3 rule. Imagine a site with 3 images. If just one of those images is deemed obscene to minors, children cannot view the site. Now imagine a site with 1,500 images. 499 of those images are deemed obscene to minors, which is 1 image short of 1/3. Children are free to view that site. So they can't see the 1 obscene image on the first site, but are free to view 499 obscene images on the second site. The First Amendment does not allow the government to pick and choose which speakers must bear a heavier burden based on an arbitrary metric such as this one.
Moreover, the law also compels speech by forcing websites to display warnings implying that legal adult content causes psychiatric harm, which is a clear violation under National Institute of Family Life Advocates v. Becerra. And moreover, less restrictive alternatives exist. In Ashcroft v. ACLU, this court recognized that parental controls and filtering software protect children more effectively.
I can ask you a question. I want to talk about scrutiny for a bit. You argue, obviously, strict scrutiny. The other side argues rational basis scrutiny. What's your best argument for why rational basis scrutiny should not apply?
Well, Your Honor, rational basis scrutiny should not apply because this constitutes as a content-based restriction.
Wait, hold on. What content's being restricted?
Based scrutiny.
I'm sorry. What content is being restricted?
Your Honor, the content restricted by HB 1181 is content they deem harmful to minors.
If you're 18, you get to see it. So what content's actually being restricted? Isn't this an age restriction?
Your Honor, content that is indecent to adults but obscene to minors are being restricted by this law.
But I don't see how it's being restricted. You're keeping away from kids, but adults can see it. What's the restriction?
Your Honor, this places a burden on adults who have a right to access the speech.
No, you're changing the topic. What is the content-based restriction? No content's being restricted. It's an age restriction.
Well, Your Honor, there's content that is being burdened. And as Reed v. Gilbert established.
Right. I'm trying to get it, right? For sure, there's a burden on accessing the content. But usually when we say a content-based restriction, the government's restricting the ability for people to publish certain things. Can Pornhub publish whatever porn they want? Is there any restriction on what they can publish?
No, Your Honor, but just another because porn companies might choose to put their obscene content at just below 1/3 simply in order to avoid the effects of this bill, which is a form of restriction.
Well, that's all well and good, but anyway, so why is this not just an age-based restriction? Isn't it about saying if you're over 18 you can see it, if you're under 18 you can't? Why is this just an age-based restriction?
Well, Your Honor, because in Texas HB 1181, it's clearly content-based when it says that if 1/3 or more of content
Right, but
is obscene.
and I get that the nature of the content triggers the restriction, but the state isn't actually telling Pornhub what they can and cannot display. They're saying who they can show it to.
Yes, Your Honor. The respondents are arguing that this is a conduct-based restriction and that it is content neutral. But Reed v. Town of Gilbert established that even if the intent behind the bill is to regulate conduct and not content, if it inadvertently affects speech nonetheless, it can still be considered a content-based restriction.
Well, you can proceed.
Okay.
This law is not just unconstitutional, it's also ineffective. HB 1181 provides no enforcement mechanism against things such as VPNs or international sites, which makes it a symbolic restriction on domestic speech and not a functional protection for minors.
I'm sorry. What do you mean symbolic? I'm not sure what that means.
Your Honor, it's just that international sites almost face there is no enforcement for them to be able to make them comply with this law. So only domestic websites are truly being
No, but
that are hosted abroad.
yeah, but I don't know what symbolic means. What do you mean symbolic?
It's in that this is not its intention, but it is practically doing this thing. And it is
So
representing
what is it? What is the intention? Maybe we can separate these things. What is the intention?
the intention, which is what the respondents will claim, is that this bill is specifically to protect minors from viewing content that is deemed harmful and obscene to them.
Okay, but it doesn't actually accomplish that intention, you're saying.
No, it does not, Your Honor.
Why?
So I think, is the argument you're trying to make, counselor, an under inclusiveness argument? And I hear those concerns, but one thing that worries me is that this court has never said that just because a law doesn't tackle every single aspect of a problem, that automatically makes it unconstitutional. A state legislature doesn't have to tackle every single issue. They could come up with the best possible way to do that. So is your argument just based on under inclusiveness, or do you see a problem there?
Yes, thank you for the question. The government must use the least restrictive means, as you stated, to achieve their compelling interest, which is protecting minors. And Ashcroft v. ACLU established that content filtering systems are a much more effective and less restrictive way.
Least restrictive means, what case is that from?
We would like to use Ashcroft v. ACLU.
Does that say least restrictive means?
Yes, they identified content filtering as a less restrictive means.
Less restrictive means. You said least. I was that. I mean, that's the standard in RIFRA. I don't know. Hold on. I'm gonna. Yeah, I don't think this test is the least restrictive means. All right, continue, counselor.
Ashcroft v. ACLU, the government must use the least restrictive means possible. HB 1181 is clearly not less restrictive than other content filtering systems or parental control systems, which is why HB 1181 fails to use these less restrictive means.
And worse, it places adult users in a dangerous position, forcing them to hand over sensitive identification just to access protected content, which is a clear chilling of speech in direct violation of NAACP v. Patterson. And
Counselor, can I interrupt you briefly to ask a question? So is your argument today, because you started with the percentages, and if the talking about the 1/3, if they had this much content on their website, is that mostly your argument, or is your argument based on the fact that they should be using content filtering instead of just an age verification requirement?
Well, our argument, it has two prongs. First of which is that this bill should receive strict scrutiny, which is which is dependent on whether it's a content-based restriction or content neutral, and also that it implicates fundamental rights by chilling adult speech. And the second part is that it does not fulfill strict scrutiny. And what you talked about with the less restrictive means, that falls under that segment of the argument, and the under-inclusive argument about the 1/3 threshold is more so for narrowly tailored this bill, to show that this bill is not narrowly tailored and does not achieve the goal that it is saying it is supposed to be used for. Yeah,
Your
thank you.
time's up.
Thank you.
Thank you, Counselor. All right, respondents, please. You have your 15 minutes.
Are we ready to proceed, Your Honor?
Whenever you're ready.
May it please the court. My name is Lauren Holt, and my co-counsel, Caroline Reedy, we represent the respondent, Ken Paxton, in his official capacity as Texas Attorney General. For the case at bar of whether HB 1181 violates the First Amendment, it is respondent's contention that HB 1181 does not violate the First Amendment, because as in Ginsburg, Sable, and Ashcroft, minors do not have First Amendment protections for explicit and pornographic material. And thus, as in Ginsburg, the government should be allowed and is allowed to regulate the access to such pornographic material by implementing age restricted material such as IDs to ensure that those who are accessing such material are adults and not minors.
Furthermore, Your Honor, Sable extended this, requiring speakers to separate their audience before disseminating harmful material that may be harmful to some but not all of their audience. Ashcroft, too, did not apply rational basis in today's case because Congress overreached beyond the Ginsburg and Sable framework due to the technological limitations of the 1990s. However, we are asking this court to reconsider Ashcroft 2 in light of new technological advancements, similar to how this court did in Wayfair versus South Dakota and overturning Quill versus North Dakota. This aligns with the Virginia State Board of Pharmacy, which permitted regulations of commercial speech to protect public welfare, especially minors. Furthermore, Your Honor, under petitioner's contention, even if this law falls under strict scrutiny, we would pass because this is a narrowly tailored law that meets a compelling governmental interest. Further, under a facial analysis, we would win because the petitioners have to show under Moody that every single application is unconstitutional in today's case, and they cannot do that. And we have a plainly legitimate sweep. As for these reasons, we respectfully request you rule in favor of the respondents, and we welcome the court's questions.
So you mentioned plainly legitimate sweep. Is this case a facial or an as-applied challenge?
Your Honor, this is a facial challenge as established in the petitioner's brief, which they're attempting to bring. Therefore, we would win under a facial challenge because they cannot show every application is unconstitutional.
So if this is a facial challenge, let's just assume for a minute, what if this were an as-applied challenge? Could Pornhub show that the effect on them in particular violates the First Amendment because they have to shut down in the state of Texas?
No, Your Honor, not necessarily. When it comes to companies such as Pornhub, it is, while they may had shut down, that doesn't mean they had to. Pornhub in particular uses a third party to
Isn't
ensure.
that how chilling speech works, though? Isn't the way chilling speech works that you don't have to actually order them to shut down, just the cost is so high that they decide to self-censor rather than wait to be punished?
No, Your Honor. In today's case, there isn't this effective chilling effect because, well, just because a company chooses not to comply with the law doesn't automatically mean that it falls under a chilling effect or that is what is occurring. When it comes to Pornhub, which is one of the most popular or most gets the most revenue for a pornographic website, indeed, and has third parties that specifically ensure that their creators aren't under the age of 18, then surely such a website would be able to implement an ID verification. Just because they choose not to does not mean that HB 1181 is exemplaring a chilling effect.
Furthermore, Your Honor, you asked the petitioners what standard of scrutiny they would like to review this case under. They said rational basis because Ginsburg does not apply. However, we disagree. Our contention is that this case is essentially the virtual case of Ginsburg versus New York, because it is doing the same kind of restriction as in that brick and mortar store. In that case, the store owner Ginsburg was required to make a bona fide attempt to ascertain the true age of its customers before selling any kind of harmful material.
But Counselor, I appreciate that, but don't you see a difference between showing a ID to a guy at the corner drugstore versus uploading your, driver's license to the cloud where who knows where it's going to go? Don't you see a difference there?
No, Your Honor, because in both instances, there wouldn't be the sort of retention of information. Indeed, when you would show your ID to someone at a corner store, then they can't simply write it down or retain that information. And HB 1181 specifically does not allow for websites or that have this pornographic 1/3 or more material and have to have this ID verification. It does not allow for them to retain such information. If they do, they'll be
Counsel, I get that, and you're right. You've described the statute to me accurately. They don't allow to retain it, but how many times in the news we see data breach, stuff that got leaked out by accident? Isn't the risk of censoring or of chilling speech so great that we shouldn't allow this to even go forward?
No, Your Honor, it's not so great. As you mentioned, every day we see these sort of data breaches and that there was a leak. It's sort of in these instances where there isn't sort of a restriction or regulation where these companies aren't going to be facing civil penalties based off information they've gathered. If anything, HB 1181 will be doing the opposite of what you're contending or what the petitioners are even contending. Instead of creating this sort of chilling effect because people fear that their information is going to be released, what's going to happen is that because HB 1181 has these civil restrictions, their information is actually going to be more secure, therefore actually promoting adults' access and usage of such material.
Counselor, I want to go back to a question I asked your friends a few minutes ago. Is this an age restriction or is this a content-based restriction? What are we dealing with here?
Your Honor, as you mentioned to them, this is an age restriction on this kind of material that is being disseminated because we are not restricting based on the content here. Instead, we are noting that minors cannot see this kind of material because it is harmful towards them and it goes towards.
And I got that. I think you're actually describing the statute, but I think your friends on the other side replied that this is content-based because the 1/3 rule triggers the application of the statute. Isn't that restricting it based on the content? Isn't it literally a content-based restriction?
Your Honor, even if we were to find that this is a content-based restriction under this 1/3 or more threshold, we can show that this does not necessarily mean that this law should apply strict scrutiny. The petitioners bring up Reed versus Town of Gilbert to make their point. However, our case is distinct from Reed because in that case, it was sign ordinances that had this time and the size of the signs that was being regulated, which is inherently content-based. However, we can look to cases such as Renton when we can see, while if the primary enabling of this law is content-based, the secondary effects of it is on these children and ensuring that they don't see this harmful material. We can apply Renton to show an intermediate kind of scrutiny if this court would like to raise the bar beyond rational.
Right. So let's say we don't agree with you, Counselor. Let's say that we're not sure if it's strict or rational basis. How would this case shake out with intermediate scrutiny?
Sorry, could you repeat that, Your Honor?
How would this case shake out with intermediate scrutiny? How would the case be resolved?
Yes, Your Honor, we would win under intermediate scrutiny as in Renton did because of these secondary effects, because we can show that there's this significant harm on the minors, but that there's a compelling governmental interest, as both us and the petitioners have asserted, in protecting these minors, and that even if we were to raise it to strict scrutiny, that this is a narrowly tailored restriction that targets minors specifically without overburdening adults' access to this kind of free speech.
Okay, Counselor, you can proceed.
Further, Your Honor, petitioners make the sort of argument that HB 1181 isn't applicable or that it won't work because of foreign entities, saying that because a lot of our vast majority of pornographic and explicit websites, as they've even further explained in their brief, that because they are are controlled primarily in international across the seas, so it's not in the United States, then that will affect HB 1181's application. And that specifically they said in their brief that the US doesn't even have an interest there. But of course, the US has an interest in sort of these international websites and ensuring that what is occurring, that the children aren't accessing such information.
Well, Counselor, but I'm sort of I'm just sort of a little bit confused with the argument here. If what you're describing is that this doesn't really burden adult speech, how do you sort of reconcile that with the fact that Pornhub is shut down and all these other companies say we cannot operate with this regime? I mean, how do you reconcile your argument with the facts on the ground?
Well, Your Honor, when it comes to, once again, Pornhub, just because a website has decided not to comply or doesn't want to, doesn't mean that a law is causing a chilling effect or is violating the First Amendment of the Constitution. Simply that these websites don't want to comply, but they can. And potentially once this law continues to be in effect, they will.
Furthermore, there is not this burden on the adult as the petitioners contend, because they are still allowed to access this material in any circumstance. They just must show an age verification, which has consistently been upheld across the board as we do this for gambling, for alcohol, for tobacco sales, whatever it may be.
Right, but Counselor, there's no First Amendment right to access tobacco or gambling. There is a First Amendment right to access pornographic material. So how do you sort of reconcile that?
Well, Your Honor, we can review back to Ginsburg. Simply the fact that because Ginsburg allowed for ID verification to ensure that the only people accessing such material was adults, and sort of the HB 1181 is sort of the online version of the act that was issued in Ginsburg. My co-counsel brings up these cases such as gambling or tobacco or alcohol, not as to say that they are First Amendment protected, that they are speech, but to say that the government always has used ID verification as a way to ensure that when material specifically can be harmful to minors and those under the age of 18 or under a certain age limit needs to be regulated, that ID verification is one of the most commonly used and easy way to do so.
Counselor, I think your friend on the other side said the test is the least restrictive means. And let's just assume for a minute that we disagree with you. Let's say we agree with your friends and we say that strict scrutiny is appropriate and you must choose the least restrictive means. Is the Texas bill the least restrictive means to accomplish this goal?
Yes, Your Honor, this is the least restrictive means. The petitioners bring up instances of content filtering that we could use that would be a less restrictive means and still be permissible, which to show that strict scrutiny should not be passed under our contention. However, we disagree. This court has tried content filtering for the past 20 years, and it has not worked. The Department of Justice recently conducted an investigation which said that 25% of material on pornographic websites that is trying to be blocked does not be blocked. But then 21% of material that is perfectly fine is blocked, showing even more burdensome on a content filtering type of restriction than it simply would be in an age verification.
What does least restrictive mean? Doesn't that mean can you accomplish your goal without imposing so much burdens on speech? I mean, maybe content filtering isn't perfect, but doesn't get you a lot of what you want.
No, Your Honor, content filtering does not get us, it's not more effective than content filtering, and it is not necessarily less restrictive under what the standard here is. Because content filtering, as aforementioned, it does not get 25% of the information that should be targeted, and then even more, it includes information in its content that should not be and is overly burdensome.
Further, Your Honor, because the least restrictive means test, it's not to just simply meet some of the interests. The interest here is protecting children from from viewing pornographic and explicit material, which has shown scientifically can harm them, and they have no First Amendment protections to. Not to protect them from some of the explicit pornographic material, but being able to access these websites off the bat that make 1/3 or more of their have 1/3 or more pornographic material, not just to ensure that in viewing those websites, they won't be able to view any of that, not just not view some of it.
Mm-hmm.
Furthermore, Your Honors, the petitioners tried to assert that there are kinds of circumvention that make this law not effective, such as VPNs. However, as your co-justice pointed out, in a case called William Yulee versus the Florida Bar, this court establishes that we need not get every single application in one fell swoop, but the most pressing ones. And so while there are these kinds of ways to get around age verification, that does not necessarily mean that this is unconstitutional. And furthermore, this kind of circumvention has a natural age leveling to it. where we are most concerned with protecting this harm, protecting younger minors such as 4, 5, 6-year-olds from this harmful material, they are not going to be.
I can interrupt for just a minute. Doesn't this really get in the way of parents? Shouldn't parents be the ones deciding what their children see? Why is the government getting involved with this?
Yes, Your Honor. While of course parents have the right to raise their children as such, the state has always sometimes taken another step into parenting when it comes to protecting the child, ensuring that a child is safe, even because the parent might not have the full capacity to ensure that by themselves. And that just because there's a parent doesn't mean the state shouldn't do so. Indeed, parents reported not feeling like they had control access of their child, what their child sees online. Indeed, even if the most diligent of parent were to ensure that their child had the most up-to-date filtering, up-to-date restrictions on their phone. They could not search anything. This child going out into public may interact with another child, may see this sort of pornographic material. It's the idea that the state has the duty to protect children from seeing this explicit material. And if we can do so, such as here, with using the most commonly of restrictions as ID verifications, then the court should do so, as in HB 1181.
As for these reasons, we respectfully request you rule in favor of the respondent. Thank you.
Right on time. Very good. Okay, rebuttal time, petitioners, whenever you're ready.
Thank you, Your Honor. We would first like to address the other side's argument comparison of HB 1181 and gambling. We believe that gambling is a form of conduct which the state has a higher authority to regulate. However, HB 1181 targets speech, expressive speech, and as established in Reed v. Town of Gilbert, all content-based restrictions must face strict scrutiny. And furthermore, the government must not restrict such content at the cost of speech.
Yeah, and the respondents used Renton. However, the online context of HB 1181 lacks the justifications used in Renton because this bill applies to the internet. There aren't these localized, tangible secondary effects that occur in Renton. So Renton does not apply to this case. Moreover, the respondents also argued that just simply the possibility of children's being able to use VPNs to circumvent these sites does not mean that the bill has to cover every possible loophole.
I want to come back to this. You were right, Counselor. I misspoke. The test is least restrictive means. And what Ashcroft says is you have to have the least restrictive means to be effective, though, right? There has to be an effective solution. The other side says that content filtering is not effective, that children can hack it, they can get around it, they can put bypass whatever. What if the text law is, in fact, the least restrictive means to do this effectively?
Your Honor, we don't believe that Texas law is the least restrictive means to do this. If it is, then I suppose we're not entirely sure on this point, but we contend that it is not, and we fully believe that it isn't because content filtering is used everywhere. It's used in our schools, it's used in our courts, it can be used effectively in the home as well. And there are several different forms of content filtering that are incredibly difficult to circumvent. For example, device level content filtering. It's impossible for a child to simply put on a VPN and bypass it because it's on their device, and there's also ISP level content filtering. As long as you're under that internet address, you cannot you cannot be able to access the site. And there's also manufacturing level content filtering where the manufacturers of the device are installing the filter. So there is simply no way for children to be able to bypass those forms.
Well, I mean, a lot of this depends on how smart these kids are, and you guys are pretty darn smart. I think you'll get around it. But my point is, again, least restrictive means to accomplish a goal effectively. What if, let's just assume in other states that content filtering does not work. And what if the government comes back and says, the only way we can do this is with age verification? That's the only way. Would this law be constitutional?
Your Honor, no, this would still be unconstitutional because it still places a
well, I know it places a burden, but if this is the only means, this is the least restrictive means to accomplish their goal, what else can they do? Do they just let these kids get corrupted by all this awful pornography?
We believe that obviously kids accessing pornography is a pressing issue, and that the state has a compelling interest to solve this issue. However, we don't think that that trumps the rights of adults. So we still believe that this bill should be struck down.
Yeah, and furthermore, the government should not be able to force a law that is unconstitutional, whether or not it achieves.
Well, I mean that's sort of the issue, right? If it is constitutional because it's least restrictive, right? You're sort of presuming the conclusion there. But go on, you have 30 seconds left.
Yeah, and again, because strict scrutiny has three prongs, it is a compelling interest, and if it is the least restrictive, it's still not narrowly tailored. So it would not pass strict scrutiny regardless. And do you want to?
Sure. And the respondents also claim that there's no risk for the data. However, because there are civil penalties for releasing the data. However, they excluded data in transmission as well as data breaches, which are very possible, which makes it so that
age verification has an inherent chill to it. Because the the respondent failed to prove that data breaches there's a guarantee against them not happening in this case. Thank you, Your Honor.
Thank you. All right, the case is submitted. All right, back on camera one. Ooh, that was good, right? So, if you could tell, I and Addie were being much more aggressive. I think I gave you fair warning. The reason why I interject so much and I interrupt you so much is to get you on your feet. It's to see how you respond when you're sort of under pressure, and it's very hard. I try to be polite in my usual interactions with people. Maybe I fail, I don't know, but I try at least to be polite. But when I'm in this chair doing this judging, I go hard. And I treated you no differently than I would treat any other law student. I pushed all of you very hard. On the substance, I think both teams really sort of know their material. You know the different tests, you know the different precedents, and you engage with me. What I liked is that you all tried to actually answer my questions. You didn't try to run away and you futzed a little bit, but you tried to actually answer them. Just some sort of polished comments. I think there's still some reading from the screen. I can tell because your eyes went back and forth. Um, maybe not. Maybe I was wrong, but it looks like some of you may be reading. No reading, right? It's got to be committed to memory. I talk with my hands a lot, and I get different advice. I would try to avoid it. If you go back and you watch the video again, you'll see it. Some judges don't mind the hands, especially in the Northeast. Northeast, I'm from New York. Northeasterners talk with their hands. It's just I do it. But when I'm at oral argument, my hands go down on the podium and I hold on to the podium. I don't let go. You don't have to give it like a death grip, but you just sort of hold on to it, and that way you're not gesticulating because it can get distracting. Yeah, so sometimes when I ask a question and I say, okay, you can proceed, you have to then pivot back to your prepared remarks, and that's actually very hard. And I do that quite intentionally. I ask you some very hard questions, like, okay, I'm done. Go back to your argument, and that sort of trip you up. I'm sorry, I know I'm mean, but I'm doing this very consciously. And you have to make sure that the runway is smooth and that you transition to a point that makes sense. A couple of times you said thank you for the question. You don't need to say that. I asked you the question. That's why I said it. Always people say that was a good question. Like, yeah, I know I asked it, right? But don't need to say that. It's very common for students to say we believe, and like believe is kind of an article of faith. Like I believe in God, right? So it's not like a word that I would usually use in argumentation. So remove we believe or I believe or we argue or we contend. Give like a legal word. Like it's our position that I would avoid the we believe line. I liked also that you were restating my question in your answer. That's actually very hard to do. Like I asked one question about, how is this different than the guy checking ID at the corner drugstore? And he said, Your Honor, this is different than the guy checking ID at the corner drugstore. That's impressive because you're able to fold my question to your answer, and that basically guarantees your answer to my question, right? If you rephrase or paraphrase the question, there's no guarantee you actually answer it. But if you fold what I said into your answer, that's actually a very effective way of doing it. You also, I mean, you're all smooth. You have very good diction. You have very good pacing. You don't pause a lot. You're all very confident. I very much love your confidence. You didn't at all seem scared when I was trying to razzle you. You were very certain in your approach. That's all I have. Addie, anything that you want to add with these four students?
I thought y'all did a really great job. I think y'all clearly know your stuff. And I can tell when you're starting to think off your feet, which like it's just fun to see when you're actually thinking about it. And I feel like I could see some of y'all's wheels turning about thinking how to respond to a question. You'll all have very good facial expressions, I think, because when I first started arguing, I had made so many, and I'm so impressed that y'all don't like y'all are honestly pretty stoic and just like very, even when he tried to frazzle you, y'all didn't show really that you were frazzled. The only way I could tell if you were was that it was taking you a second to get your answer out, but you were thinking about your answer. Um, I I think that y'all all did a really good job. The transitions are hard to fit. It's hard to smoothly transition when he drops you like that and says, "Okay, never mind." You just have to pick back up somewhere. So that's something that I know that y'all probably aren't used to that. That's something I would work on. Just kind of have a prepared, like maybe keep what I do. My trick is I just keep talking about the same thing until I remind myself what I want to talk about next, or I just say like more off like on that point or something. You just want to spit something out immediately so you don't look like you don't know what to say next because you are the expert. You are the expert on the argument. You know what to say next. You have so much to say. I'm sure y'all didn't even get all of it out this time, and you're probably like, "Oh, I wish I mentioned this." But I thought y'all all did a great job. Very good voices and very confident for your age. Y'all should be very proud. Y'all made some good points too that I was very impressed with.
Okay.
Thank you so much.
All right. Do you have any questions for us?
Um, uh, we noticed when we were like practicing for this that like when we were trying to come up with answers on the spot, we say like a lot of filler words. And what we just ended up doing was like pausing. I wonder if there's like a better solution for that because it's like so ingrained to just like start saying filler words when you don't know what to say.
Addie is the moot court champion. You want to give him some thoughts on that one?
I used to do the same thing and I would pause and then I started pausing for too long. Then I
Yeah.
just started talking and you just yeah, there's at some point you can't avoid filler words, but the more you practice saying the same argument over and over, the less you say the filler words because the more you think back to another argument and you remember what something you wanted to say next or something like that. So I think that just with practice is the best way to keep the filler words out because it becomes more rehearsed, not in a it becomes easier to do and more rehearsed because you're much more relaxed because you know what you're going to say next since you've done it so many times. I just say it over and over in my head. Like I would before an oral argument, this one. I'm not never actually oral arguing for a real court. I would just argue back and forth with myself all day long, the
That's
whole
so
entire time. Which
yeah.
I'm sure since you're laughing, it seems like you'll probably do that too. But that's what I would do, and I think that that would just help me. Just like the nonstop practice made it to where it would just fall out of my mouth whenever I would open it.
I mean, I talked to a lot of lawyers who argue for the court, and one technique they use may sound crazy is index cards, right? So they write questions in index cards and they just pull it out the deck and they see how quickly they can answer it. They pull out a card, right? Pull out a card. And that forces you to um, move quickly on your feet. It's often said, and I don't expect this of a bunch of high school students, but it's often said that a Supreme Court advocate should have no surprises. That when you get to the US Supreme Court, you have anticipated every possible question and you thought of an answer to every possible question. It is very rare, and in fact, is considered bad when a Supreme Court advocate gets up to the podium and then he gets a question and he's like, oh man, I don't know. I can think of one one case. This was actually a very important case. This was a Bergefell v. Hodges, the gay marriage case from 2014 or so. The lawyer was Don Verrilli. He was the Solicitor General, the government lawyer for the Obama administration, and was either Chief Justice Roberts or Justice Alito. I can't remember which one. Asked him, so gay marriage. Would this require religious college to allow gay housing for gay couples? Like on-campus housing, dormitories. And he actually said, Your Honor, I haven't considered that question before. That was a big question, right? It was like a slippery slope question, and he hadn't considered it. So rather than making up an answer on the spot and potentially making a bad statement, he's like, Your Honor, I haven't considered that question before. So I would not recommend you use that often or even ever, but it may come a time in your careers where there's a really important question that's asked and you haven't considered it, and you realize, oh, if I answer that could hurt my client, right? That could actually hurt my case. But this is just kind of something you have to work on. There's not really any other way around it. I think you're all pretty fast on your feet, Eddie. I don't see you stumbling. You're all very smart, and I mean that sincerely. You're all very smart, but also you're very quick. And you saw what I was asking you. Even if you didn't want to answer it, I think you at least saw what I was trying to trap you. I was trying to like corner you in, and you saw it coming, and you're trying to like run away, like, I don't want to do this. But it's almost this game like a tap dance. And anyway, that's all I got. Anyway, but this is very impressive. I think all four of you are really strong. I am not sure how I'm going to pick the teams for the next round. I'm going to struggle because you're now match three. I have two more after this. One more today, another one tomorrow. I hope to finish the grading by the end of this week. Maybe it might take longer to think of these things through. But all the teams are very strong. You all have bright futures ahead of you, whether or not you work with me or not. Um, you know, it's all just very impressive.
Thank you so much.
Thank you.
Thank you.
All right, that's all I have. Any other questions you want to ask me?
Did you want to? No. Okay.
We're good. Thank
Very
you.
good. Thank you.
All right, well, have a lovely day. Thanks again for accommodating the schedule, and I will talk to you all soon.
Bye.
Thank you.
Good luck.